Hi guys, I hope you're all doing well. Uh, I decided that today let's do some property law. There is a recording of the property law session that I did a couple of days ago. It was actually a live session, and unfortunately, I'm not able to download it and upload it on YouTube. So I'm just going to do a new session. And from this session, I'm not going to deal with many cases. So I will leave the cases for you on the chat box below. And then the textbook that I'm using today is the Introduction to the Law of Property. I'll also put it on the chat box below. So it's the Introduction to the Law of Property. It's the 8th edition of J.G. Horn, Knobel, and VC. So that is the introduction to the law of property. I'm not going to be going through the textbook as well. I'm just going to go through the notes that I have. So we're going to do summaries of a couple of important topics that I would like to share with you today. If you like this video, you can just click subscribe and then share it with your friends as well. And I hope it's going to be very helpful. So let's start. Let's start with the original acquisition of ownership. We know that in the original acquisition of ownership, ownership is not dependent on the lawful ownership of the previous owner. That is, transfer of ownership is not dependent on the lawful ownership of the previous owner. And then we also know that the benefits and obligations of the previous owner are not passed to the new owner. So if there is no previous owner, acquisition takes place through appropriation. It is also called occupatio in Latin. So if there is no previous owner, acquisition takes place through appropriation of a thing that is not owned, which in Latin is called res nullius, or a thing that has been abandoned, that is res derelicta. So something that is not owned, res nullius, or something that has been abandoned, res derelicta. Let's also briefly touch on the original acquisition of ownership, where there is a previous owner, but ownership is passed to the new owner without the previous owner's cooperation. This is by means of accession, prescription, and expropriation. So above we spoke about appropriation, and now we have a question. What is appropriation? Appropriation is the unilateral exercising of physical control over a corporeal thing that can be owned but is not owned by anyone. That is res nullius, like I said, or res derelicta, with the intention of becoming an owner. So I will repeat, appropriation is the unilateral exercising of physical control over a thing that can be owned but is not owned by anyone, with the intention of being the owner. The intention element is very important. Most of everything that we deal with in property law, and I think in all other areas of law as well. So with regards to the appropriation, there are certain requirements that needs to be met. That is physical control. You need to have the intention of being the owner, animus domini, or of a corporeal thing that doesn't belong to anyone. So if you can look at the definition of the appropriation, you'll see that it is the unilateral exercising of physical control. Physical control is also an element within the requirements of appropriation over a corporeal thing that can be owned but is not owned by anyone. You will see that is also an element of the part of the requirements. And then with the intention of becoming an owner, which is animus domini, that is also part of the requirement. So if you do understand and you know the definition of appropriation, you'll be able to list the requirements of appropriation if a question is posed to you in that manner. So one of the important cases in this chapter is Reck versus Mills. In this case, the respondent attached a rope with a buoy to a condenser of a shipwreck to indicate that he had physical control over the condenser for the purpose of salvaging it. The court found that the rope with a buoy was not an adequate indication of the physical control of the respondent over the condenser, since the control must place the controller in the position where he can use the thing as he wishes, right? So in this particular study unit, or in this particular chapter, there's also things that you need to look at, things like accession, manufacture, mixing and fusing, acquisition of fruits, expropriation, and prescription. If you want me to cover those in details, please leave the comments down below. I will definitely do a session on those, but just let me know if you want me to do a session on those. Just leave me a message below. Thank you, and don't forget to like and share. Okay, so another case that is very important here is Standard Vacuum Refining Co. Company of South Africa versus Durban City Council. This is a case where it dealt with the oil tanks that were not attached to the land, but they weighed more than 450 tons, and they were regarded as immovable because they were manufactured on that particular land that they were so they were attached by weight. So these are the cases that you need to know that are very much relevant to this particular chapter. Okay, so now let's move to the derivative acquisition of ownership, and the related cases in this chapter is the case of Cape Explosive Works Limited versus Denel, and then there's another case which is Info Plus Chic and another, and then there's a Groenevald case, and then there's Eskom versus Rollomatic, and then there's Quenty motos versus Standard Credit, right? So these are the cases that you might want to read. So if you want me to do like a session just talking about these cases, please leave me a message on the comment section. I'll definitely do a session of case discussions for these particular cases, but I'll just wait to hear from you. Okay, so let's continue with the derivative acquisition of ownership. We know here that the cooperation of the previous owner is not a requirement. So is a requirement. I'm sorry, that was original. So now with derivative acquisition of ownership, we know that the cooperation of the previous owner is required. And then we call this, we say that there is a bilateral juridical act that is required in terms of ownership to be transferred. So we have the current owner that is transferring, that is transferring to the new owner, the one that is going to accept. Okay, so now the new owner must accept the rights that come from the previous legal owner, and she must also accept some obligations and limitations that exist in respect of that particular thing. For example, if you're buying a house, you buy a house also and you accept that there are the levies, the rent, the rates that come with it that you'll be liable for every month if there is such for that particular property. And also very important, just highlight here that you need to understand the nemo plus juris rule, that no person can transfer more rights than you already have. So you cannot transfer more rights than you already have. Please keep that in mind. It's called the nemo plus juris rule. Okay, so there are requirements for the transfer of ownership. Just summarized, I will give you 7 requirements. The first requirement is that the thing must be negotiable. The second one is that the transferor must have the contractual capacity. So now the owner of the property, so myself as the owner of the property, I must have the contractual capacity. We know what contractual capacity is. The transferor must be the owner of a thing. So you must be the owner of that particular thing before you transfer it. And then number 4 is that the transferee must have the contractual capacity to accept the transfer of ownership. So you as the buyer or as the receiver, you must have the contractual capacity to accept the transfer of ownership, right? And then number 5, the ownership must be accepted by the transferee or a nominee. And then number 6, transfer of ownership in movables In movables is delivery, and then in immovables it's a registration in the deeds registry. And then the last one, number 7, is that the delivery of the movables and immovables must take place with the intention of the owner to transfer ownership, with the intention of the transferee to accept ownership. So you understand that the intention is very important in almost everything that you deal with. The owner must have the intention, the transferee must have the intention to accept as well. So in terms of deliveries, there are also various forms of deliveries. So we've already said here that the transfer of movables delivery must take place, and then in the transfer of immovables, registration in the deed registry must take place. So now let's talk about the types of deliveries that we're going to deal with. First of all, let's deal with the actual delivery. So actual delivery, this is the case where you hand over whatever it is, property, to the transferee in a way that you as the transferee will be able to exercise physical control with the intention of being an owner. For example, I sell you my property law textbook and then I hand it to you, right? I hand it over to you, So you also need to know that delivery can also be done by a friend or a representative that you elect. Okay, so now let's talk about constructive delivery, which has a couple of categories, and those include, number 1, it's a symbolic delivery, right? Symbolic delivery, it's because due to the nature and the size of the thing that you have, and that it can't be handed to the transferee just like actual delivery, so you can't hand it over to the transferee. So by means of an instrument, you give a symbolic delivery which enables the transferee to exercise physical control. So you give them an instrument, and that instrument should be able to enable the transferee to exercise to exercise physical control, right? So for example, if you are, maybe you have something that you have sold, but it's in your warehouse and it's too big for you to be able to take it to that person. So if you give them the key to the warehouse for the contents inside, so the key, it's a symbol, right? And then for the contents inside, you are telling them that, okay, I'm giving you this key so that you can have physical control over the contents inside, right? So in the case of a car, the delivery of keys, registration certificate, or a license disc with the intention of transferring ownership, then the new owner will now be enabled to have physical control of the car with the intention of being the owner, and the delivery of the car must have taken place as well. So for that particular scenario, you can visit the case Unitrans Automotive versus Trustees of the Rally Motors 2010. You can use this as a referral question, as a referral answer. Sorry, so they give you that particular question, and then you can use this case as a referral case. Okay, and then let's talk about delivery with a long hand. So due to the nature and the size, you point out. So we spoke about the symbolic. We said you give a symbol, you give the key to the warehouse so that they can be able to exercise physical control, right? So deliver with the long hand. So this is due to the nature and the size. Then you point out and be like, hey, there is your thing or whatever it is, right? And then this thing that you point it out to the transferee so that they can have physical control. You point it out so that you're giving them physical control. So you must also look at the case of Groenevald versus Merwe. That's the one that outlines the requirements of delivery with a long hand. And also please look at the case of Eskom versus Rollomatic. Okay, Eskom versus Rollomatic engineering. And then so if you want me to discuss these cases, leave me a message on the comment section below. I'll do a session that will focus on the cases. Okay, and then number 3, let's talk about delivery with the shorthand. The case here is Info Plus versus scheelke. So when the transferee is already in physical control of the thing, but without the necessary intention of being an owner, so that constructive delivery can take place, the intention of both parties change, right? So now let's give an example. you borrow me your cell phone and I use your cell phone, and then there's a change of intention. I give you an offer. I'm like, hey, I want to buy your phone, but I'm already in control of that cell phone, right? So now what changes is just the intention. If I pay you the money, and then you're not going to deliver the phone again because the phone is already with me. So it's just the change of intention from myself, because now I have the intention of being the owner, and then from the actual owner, now they're changing their intention to actually wanting to transfer the ownership rights from themselves to myself. Okay. Then let's talk about number 4, that is constitutum possessorium. Okay, constitutum possessorium is when the thing is transferred without the thing being actually delivered to the transferee. So transfer also takes place by means of change of intention, just like the one we spoke about. So in this scenario, then the thing remains in physical control of the owner, who exercises physical control for another valid legal cause. So the example that I'm going to give here is the example of let's say, for example, you go to a shop where they sell wedding dresses, and then you go and buy yourself a wedding dress, and then just because the wedding dress doesn't fit you, or you want to do some alterations, you pay for it and then you leave it there. So you are already the owner of that wedding dress, but because there is a valid legal cause, you want them to alter that wedding dress, so you can leave that dress there. Even the owner of the shop, now she's keeping that dress with a different intention, because they are no longer owner of that dress. Please check the requirements of the constitutum possessorium on page 166 on the textbook that I mentioned, which is the Introduction to Property to the Law of Property by J.G. Horn, Knobel, and Vies, the 8th edition. Okay. Okay. Let's talk about atonement. Atonement is a little bit complicated, not too complicated, but I'll try and simplify it for you. Okay, atonement. So in the example of atonement, we're going to have transferor. We're going to call transferor A, and then transferee, let's call transferee B, and then the third party, let's call the third party money more bank. Okay, so now we have the transferor A, let's call A Amanda. Now we have the transferor A, which is Amanda, and then we have the transferee B, right, which is okay. Let's start it from the top. Okay, you see, now I'm confusing myself as well by giving these things names. Okay, let's just deal with A, B, and C. Okay, so we have transferor A, we have transferee B, and then we have third party C, right? And then A, it's let's say A is a dealership, right? Dealership that sells cars. And then transferee, it's B, that is the bank. And then the third party is C, that is yourself, right? So now you go to the dealership, you purchase the car, but you purchase it on credit. That's where transferee B comes in, right? Now transferee B comes in to pay for the car, and then you are the third party, you are C, you want to exercise control of the car. So what happens is that, okay, the actual owner, that was the transferor A, excuse me. Okay, much better. Transferor A now is selling that car to you, but you're not paying for the car. The bank is paying for the car. So now both A and B have the intention that ownership be transferred from A to B. And then there's also an agreement that you, C, will take you will exercise control of that particular car. That is atonement. Okay, so if you do have any questions and you don't understand anything that I've explained above, please leave me questions in the comment box below. Okay, let's talk about protection of ownership. This is very interesting and can be complicated for others, but yes, let's talk about protection of ownership. So, protection of ownership, what this essentially means is that if entitlements of the owner are infringed upon, there are several remedies available. We have real remedies. We're going to deal with them now, and then we have delictual remedies and the enrichment remedies that we're going to briefly touch as we move. So first of all, let's talk about re vindicatio. Immediately when I'm talking about re vindicatio, you must think of the case Chetty versus Naidu. Re vindicatio is an action where an owner can recover an existing identifiable thing from a person who is exercising unlawful physical control, right? And then we have the requirements for the re vindicatio. Remember what I said from the beginning. I said once you understand the definitions of terms, then you'll be able to answer any question that is posed to you. So now with re vindicatio, we have the requirements. So the requirements of re vindicatio, the owner must prove ownership of a thing. Only an existing identifiable thing can be reclaimed, and then the property must be in the control of the defendant when the action is being instituted, right? So let's go back to the definition again. So the definition says, and it is an action where an owner can recover an existing and identifiable thing from a person who is exercising unlawful physical control. Look at the requirements again. The requirement number one, an owner must prove ownership of a thing, right? You must prove that ownership of a thing. And then requirement number two is one that is on the definition that says an existing identifiable thing can be reclaimed. So it has to be existing and it has to be identifiable. Please keep that at the back of your mind because we will come back to this when we get to other remedies. Okay. So now let's talk about the next one, actio negatoria. Actio negatoria is the real action aimed at protecting an owner's right or capacity to exercise his or her entitlements arising from her ownership of movable or immovable ownership, right? So that is a real action aimed at protecting an owner's right or capacity to exercise his or her entitlements arising from her ownership of movable or immovable ownership. Okay, another one is the interdict. Let's talk about the interdict. The interdict is very important. Each and every person must know what an interdict is. It is a summary court order which is usually issued upon an agent application by which a person is ordered to either do something or to stop doing something. So the requirements for the interdict, you must prove of a clear right with regard to the property. Number two, you must prove that the respondent infringes upon the right unlawfully and in an ongoing and continuing way, and that there's a reasonable expectation that such an infringement will occur in future and it will cause the applicant damage. And then number three is that the reasons why there is no effective remedy available to the applicant. That is a very important requirement, right? So without spending more time on the interdict, only have 40 minutes. Let's talk about the declaratory order. The declaratory order is a court order that sets out the rights and obligations of parties to a dispute before an actual infringement takes place. Once a declaratory order has been made, it is binding to its parties, right? There's also requirements. You must also check those requirements from the textbook. So now let's move over to the delictual remedies. The delictual remedies, I know most of you that have read something or understand what law of delict is, you will understand what delictual remedies are. So delictual remedies do not restore physical control over a thing, but they are only for compensation for damages or injury that the owner has experienced in respect of their property. So they are not for physical control like the ones that we spoke about. So these ones are solely for the purposes of compensation, okay? So let's start, let's talk about actio ad exhibendum, right? Actio ad exhibendum. It is instituted by the owner of a thing against the controller who alienated, destroyed, or consumed a thing with malafide intentions, in which case the value of a thing can be claimed from such a controller. Just a recap. When you institute actio ad exhibendum, it is because you can't institute a res vindicatio because it's either the thing in the actio ad exhibendum, the thing doesn't exist anymore or it's unidentifiable, right? So you can check out the requirements for this on the case RMS Transport versus Priskin Holdings. Okay. Now let's move over to the conditio furtiva. Conditio furtiva. This is a special delictual remedy used to recover a stolen thing with its fruits or its highest value since theft from the thief or after the thief's death from its heirs. This is only in situations where property was damaged or lost after being stolen. So let's say, for example, now somebody steals your thing and then they lose it, right? So you can't obviously game the thing. You can't use Raven. You can't use Raven Casio because this thing is not identifiable anymore, right? It has been lost or it has been stolen. Okay, so you use this special conditio furtiva. So if a thing is still under the control of a thief and is undamaged, you can still use your Raven Casio and you can still use actio ad exhibendum in the case where the thing has been destroyed or consumed on purpose. Please remember that actio ad exhibendum is when the thing has been destroyed or consumed on purpose. Okay. Let's talk about the action for delictual damages, which is also called actio legis aquilia. That's how I pronounce it. Might be wrong, might be right. I think as long as you're able to write it, it's not a transmesh. So this is an action used to claim compensation for losses. So you can say this is an action that is used to claim damages for losses suffered as a result of the defendant's unlawful actions. And the requirement for the action for delictual damages is the proof of patrimonial right or an interest in the property, proof of patrimonial loss suffered as a result of an unlawful and culpable action of the defendant, and then the proof of causal connection between unlawful action of the defendant and the loss. Okay. And then lastly, we're going to look at the enrichment claim, which is the owner of a thing can use an enrichment claim from the controller, the amount which the controller's estate has been enriched without the cause, if that enrichment was the result of consumption or alienation of a thing. So if you got your estate enriched, right, in a way that it kind of maybe puts me at a disadvantage, and then you are enjoying the benefits that you're not supposed to, or something that you could have worked for, right? That is unjustified enrichment. So you can use an enrichment claim to claim whatever it is that I can use the enrichment claim to claim whatever it is from your estate that has gotten enlarged because of something that you didn't deserve. So ladies and gentlemen, you can leave me some comments in the comment section below. If you like the video, give it a thumbs up. You can share, you can subscribe, and then invite your friends to come and learn. I have different videos for different modules. So the more you learn, the more I learn, the more we all learn. Please like, share, comment, and thank you so much, and keep well.